Okay, so one of the things that the new laws regarding DWI require regarding deferred adjudication probation is the installation of an interlock device, a deep lung device, which is that breathalyzer on your car. Now, there are some exceptions and conditions to that, and I'm gonna jump into those. But again, this is a series about the new DWI laws and how they have changed in significant ways, and they offer more reasonable results and opportunities for Texas citizens to navigate. If you have this, look, I hope none of you ever have this kind of brush with the law, but frankly, statistically, 90% of Americans have contact with law enforcement because of a traffic offense. And of those 90%, more than half are alcohol-related driving offenses. So the other half probably speeding, but that's another topic. The alcohol-related driving offenses now have this deferred adjudication, putting the defendant on community supervision or probation. And as a mandatory condition of deferred, a deep lung device, also known as an interlock, also known as a breathalyzer, goes on the car. And there's a monthly monitoring fee, the expense of purchasing the deep lung device, and the reporting. So these are all fees that, that can be oppressive to clients, especially indigent clients who are, young, poor Texas citizens just out of high school, or, in a community with not a lot of opportunities or resources, and they just can't afford these. So there's things that can be done to help them. The judge can make findings that the expenditure could be cut in half, in some cases waived if there's a drug and alcohol assessment that comes back positive. And, so there are opportunities even for the poorest of Texas citizens to be able to comply with deferred disposition and either get an interlock at a reduced cost and a reduced monitoring fee. I mean, almost half can be waived off by the judge. Here's the way you can mess that up and one, not only be yanked off deferred disposition, but and then put on straight probation or worse, depending on how angry the state prosecutor and the judge may get about it. But don't blow hot into the interlock if you've gotten reduced fees because of indigency or need. So if you blow into that interlock and you're 0.9, that judge is very likely to not only snatch the soul out of you, but revoke your deferred, have a motion to adjudicate guilt heard, sanction you. I mean, these are problems you don't want, I promise you. And that judge doesn't want to do it. So if you are an indigent or client with meager resources and you have asked your attorney to help you get reduced or waived some of those interlock service installation monitoring fees, do not blow hot into that device, because that's just a train wreck, and you don't want to be on the train when that thing comes off the tracks. Okay, so just take care of your business, use common sense, don't blow hot into the interlock, especially if you're on deferred disposition and you're still motoring through the probation process. It's just not a good idea, and it will not only upend your goals, but it's likely to incur the wrath of the state of Texas and the court for having gone to lengths to assist you financially, and you're not taking care of your business.